Good evening, friends. Today I am going to discuss about some important definitions of FMT. So today I will discuss about the legal procedures definitions. So these are the very vital points for viva exam. First, what is forensic medicine? So forensic medicine is the legal medicine or state medicine. So forensic medicine means the forensics. Forensics means forum or meeting place. So forensic medicine basically derives from the term forensis. This is actually a Latin term. So what is forensic medicine? It is the application of the principle and the knowledge of the medical services to legal purpose and the legal proceedings so as to aid the administration of justice. Next is the clinical forensic medicine. So clinical forensic medicine, it is the branch of medicine that deals with both the provision of clinical services, that is diagnosis, treatment and management to the patients and the medical legal aspects of the patient care. About forensic pathology, investigation of sudden, unexpected and or violent deaths that include determining the cause of death and the circumstances of how the death occurred. So here medical jurisprudence, another important term. Medical jurisprudence, it is the application of the knowledge of law in the relation to the practice of medicine. It includes doctor-patient relationship, doctor-doctor relationship and doctor-state relationship. Next point is inquest. An inquest is an inquiry or investigation into the cause of death, where death is apparently not due to the natural cause. There are two types of inquest in India, mainly the police inquest and the magistrate inquest. About police inquest. Police inquest comes under section 194 BNSS. So the police inquest is held by the police officer known as the investigating officer or IO, not below the rank of the senior head constable in all cases of unnatural deaths and the exceptions mentioned under the magistrate inquest. So 4 Qs, there are identify the decreased place of death, time of death and apparent cause of death. Remember, even if there is some discrepancy between the inquest report and the postmortem report, the list of injuries mentioned in the postmortem report will prevail over the details of the inquest report. So at first we know about the magistrate inquest. The magistrate inquest. The inquest is conducted by the district magistrate, judicial magistrate, SDM and any executive magistrate empowered by the state government, such as the sub-collector or tahsildar. So magistrate inquest comes under section 196 BNSS. So indications of the magistrate inquest. In which cases the magistrate inquest mainly done? That is death in the police encounter, that is death in police custody, rape in police custody, disappearance or death in the person in police custody or during the police interrogation, death of a convict or in jail or a juvenile offender is remained the home. Exhumation, that is where the body is dug out of a grave. Rape alleged to have been committed on any woman in the custody of by the police. Dowry death, the suicide or death of the woman within 7 years of the marriage. Death of a mentally ill person in a psychiatric hospital admitted under certain provisions of the mental Healthcare Act 2017. Remember earlier inquiry by judicial magistrate and metropolitan magistrate was mandatory in case of the custodial death or disability or custodial rape. But now any magistrate or judicial or executive can hold an inquiry. Another type of inquest is coroner inquest, but this is not practiced in India now. About the courts. In India, a court of law is a place where the legal matters are decided by a judge or a magistrate to adjudicate legal dispute between parties and carry out the administration of the justice in civil, criminal, and administrative matters in accordance with the rule of law. So in India, there are mainly two types of the courts. One is civil court and another is criminal court. Civil court, a court of law that tries to determine civil cases, usually disagreements between the individual pupils or private organizations rather than with the criminal activity. So judge can order the payment of money or fine to make the decision about family, home or land. The criminal court. The criminal court is a court that has the jurisdictions and authority to try and punish individuals accused of committing a crime as per criminal law. So at first, what is criminal case? Prosecution by the state against a person or organization for committing the public wrong, offense against the state. This is the criminal cases. About criminal courts, there are the mainly Supreme Court, High Court, Session Courts, Magistrate Courts. These courts are the criminal courts. So, know about the powers or of a judge or magistrate. The Supreme Court. Supreme Court can imprisonment for any period, including the death sentence. High Court can do same as the Supreme Court do. That is imprisonment for any period, including death sentence. District and Session Court can do everything about the High Court, but cannot ensure the death sentence without the confirmation of High Court. So they need the confirmation by the High Court. Assistant Sessions imprisonment up to 10 years. And Chief Judicial or Chief Metropolitan can imprisonment up to 7 years. First class jurisdiction or metropolitan, this is imprisonment can up to 3 years, and second class judicial can maximum give the punishment of imprisonment for up to 1 year. And about the monetary fines, the Supreme Court, High Court, District or Session Court, Assistant Session Court and Chief Judicial can fine any amount. But the first class judicial, metropolitan and second class judicial, they are limited by respectively 50,000 and 10,000 only. About sapnia or summons. So sapnia, this is the Latin term. This means under the punishment. It is a document compelling the attendance of a witness in the court of law under the penalty or a particular day, time and place for the purpose of giving evidence. This comes under section 63 to 71 BNSS, deals with a summons. So Their sapnea can be two types. Sapnea duces tectum, where person is required to bring certain documents or other evidences to the court. Usually the postmortem or medical legal reports specified in the sapnea. And the sapnea ad testicandum, that is the requires the individual to testify before the court. The person will be examined in the court. That is sapnea ad testicandum. That means someone added testification. And the sapnea duces tectum, this means the someone to take. You have to take something. In sapnea, there are the priority orders. Suppose you have summoned by the two courts on the same day. One is criminal and the other is civil. So where you should go? You should attend the criminal court. But as criminal courts have the priority over the civil courts. Another case, you have the summon on the same date at the high court and the lower court. So you should attend the high court irrespective of any civil or criminal cases. You should always prefer the high court to attend your summons. And if a witness receives two summons on that same day from the same type of the court, you should attend the court from which he received the summons at first and inform the other court. This is mandatory. And if you don't attend the sapnea, then in criminal cases, the court may issue the notice under section 389 BNSS if it finds that the witness neglected to attend the court without any justification, may sentence him to imprisonment and fine, or may issue the bailable or non-bailable warrant to secure the presence of the witness. In civil cases, it is liable to pay the damages. So it is conduct money. Conduct money, it is the fee offered or paid to a witness, educator, in civil cases at the time of the serving the summons to meet the expenses towards the attending the court. Remember, conduct money is only given in the civil cases, but in criminal cases the conduct money is not given. About medical evidences. So medical evidence, what is medical evidence? This is defined as the legal means to prove or disprove any medical legal issues in the questions. So it is the two types, that is the documentary type and the oral type. Documentary and oral type. So documentary evidence, it comprises of all documents, including the electronic records, to be produced before the court for inspection during the course of trial. This again can be of three types, that is the medical certificate, medical legal reports, and the dying declaration, and also added the dying deposition. So medical certificates, first of all, the documentary evidence, this actually two types, that is the primary and one is secondary. In secondary, this comes the medical certificate, medical legal reports, and dying declaration. So primary, the document itself produced for the inspection of the court. In secondary, the certificate copies of the original documents issued by the authorized person. So medical certificates are the secondary and issued by the qualified registered medical practitioner or RMP in relation to the health, death, insanity, or age or sex. This is medical certificates. Medical legal reports, Medical legal reports are prepared by the doctor at the request of investigating officer for his guidance, usually in the criminal cases. Example: injury, postmortem, sexual assault, pregnancy, abortion, or delivery. And a dying declaration. A dying declaration, means the later mortem. Later mortem means the words said before the death. So what is defined? It is defined as it is the written or oral statement of a person who knows that the death is imminent, concerning that what he believes to be the cause of the circumstances of his death. So actually it says a dying declaration is called a later mortem, which means the word said before him. The person knows that he will die after a few minutes and death is inevitable, so he declares the cause of the death to a doctor or police or the law persons. So the code applicable for this section 226 BSA Bharatiya Sakshya Adhiniyam, previously 32 Indian Evidence Act. This is incorporated. So here comes about the dying deposition. Dying deposition During deposition, the magistrate records the evidence after administering oath in presence of the accused or his lawyer. There is no provision of the dying deposition in the Indian Evidence Act, so it is not followed now in India. But dying deposition was more preferred over dying declaration, because dying deposition will be still valid even if the person survives, but dying declaration will not be valid if the person survives. To validate the dying declaration, the person have to die. And next comes the oral evidence. Oral evidence, it indicates all statements which the court permits or which are required to be made before the court by witness in relation to the matters of the fact under inquiry. Fact under inquiry. So it comes under section 2 BSA. It must be direct and it must be the evidence of an eyewitness. So oral evidence is more important than documentary evidence as it permits the cross-examination. Documentary evidence is accepted by the court only after the oral testimony by the person concerned, and video conferencing, which has been allowed by the court, is an oral evidence in electronic form. So comes about witness. What a witness? A witness is a person who gives sworn testimony, evidence on the court law as regard facts and or interference that he can draw from this. So eyewitness, this witness means this the person observed the case or the crime and solemnly declares in front of the court and presents his views and the knowledge about the case in front of the court. So he is a witness. So there are two types mainly, that is common, precipitant, ordinary or lay witness, and there are expert or skilled witness. So witness in expert witness is a person who has been trained or skilled in a technical or scientific subject. He can volunteer his statement if he feels that the justice is likely to be miscarried going to the court, having failed to elicit an important point. So doctors are not necessarily the expert witness. Medical practitioners are considered as a professional witness. Um, the difference between the professional witness and the expert witness is that the expert can offer the opinions beyond the fact of what they have the personally witnessed, and they can record to questions about the hypothetical situations posed to them. In most cases, a medical evidence is the expert witness and expert evidence. But when a doctor describes the dimensions of an injury, example, stab wounds, she acts like an ordinary witness. But when opines the cause of the death as a hemorrhage due to antemortem injury to the femoral artery, he acts as an expert witness. So doctor can act as both the lay witness and as the skilled or expert witness. Now it comes about to the hostile witness. Hostile witness is a person who willfully or with motive, bribe or intimations conceals the part of the truth or tells a lie to or give completely false evidence to the court. So it is obviously contrary to the statement the witness made in the previous deposition, example statement recorded by the police. Any witness, common or expert, can be declared hostile witness. So about perjury or false evidence. A witness who, after taking oath or making solemn affirmation, willfully makes a false statement, which he knows or believes to be the false, section 227 BNS and 383 BNSS, is liable to be the prosecuted for perjury under section 229 BNS, with imprisonment up to 7 years and fine up to 10,000. So preservation of evidences. Here comes the preservation procedures. Preservation of evidence can also be referred as recording of the evidence. The prosecutions and the defense, they are the two parts of this evidence prosecutions. The lawyers are the prosecution lawyers, the public prosecutor maybe, and the defense lawyers is another part of this recording evidence. And the witness can also be the recording of the witness or preservation of the witness. Prosecutor witness, that is prosecutor witness and the defense witness. So we get the four part of the recording the evidence: public prosecutor, defense lawyer, prosecutor witness, and the defense witness. So procedures. The oath. The oath comes under section 223 BNS. Sworn by the God or solemnly attest, and the refusal can, if refused, the punishable under 213 BNS, and the exemption for child for less than 12 years of the age, and perjury is 227 BNS, false evidence under the oath, and fabrications 228 BNS, punishable under 229 BNS. Examination is defined by 142 BSA. Here the examination in chief or a direct examination is conducted by same side lawyer, and the leading questions are not permitted, and the objective is to place the facts before the court, and the fact interpretation, expert witness. Cross examination is conducted by opposite side lawyer, and the leading questions are permitted, and objectives are elicit the favorable facts test accuracy and discredit the witness. And the re-examinations or redirect examinations is conducted by same side lawyer, and leading questions are not permitted. And objectives is to clear the doubts of the cross-examination, avoid the fact misinterpretation, no new facts are placed. And finally, the court questions. Court questions: a judge may ask any question to the witness at any stage of the trial to clear the doubt of the points. The deposition of the witness is handed over to him. The witness, after carefully going through it, is required to sign at the bottom of each page and on the last page immediately below the last paragraph, and to initial any corrections. Section 313 BNSS says the witness should not leave the court without the permission of the judge. So leading questions. The leading questions is interesting questions. Any questions suggesting the answer which the person putting is wished or expects to receive. It includes the material fact and admits to of a conclusive answer by simply yes or no. For example, was the length of the knife 15 centimeter? Instead, the question should be for the length of the knife. So this is the leading questions. So leading questions must not be asked if objected to by the adverse party in an examination in chief or in re-examination. Expect with the permission with the court. Except. So leading questions are where the witness can reply with yes or no answer, and the person and the lawyer asks the confirmation of this his proposals. And the loaded questions they contain the false or unproven assumptions that make it difficult to answer and are objectionable. For example, say, have you stopped taking a bribe for medical legal reports? Indirectly asserting that the person used to take bribes. So these are loaded questions. Leading questions and loaded questions. Leading questions are yes no questions, and loaded questions are the false assumptions. And the lawyer thinks that the person does the misdeed. That is the loaded question. So this is the chapter of legal procedures, chapter 1. Next chapter I shall discuss after this video. Watch that please.